Good morning, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. We'll start our day with Judge Simpson.
Really? Where is my second room? That's why, because she looks tall. Okay, they're in both courtrooms, but they need to have somebody here.
I understand. I'm just sharing. I can really, Your Honor, on behalf of Mr. Kurt Kwiatkowski, correct.
Sir, state your name, please.
Kurt Kwiatkowski.
Judge, can we just approach very briefly? I know. Start.
All right, he's already gone to mute. Let's go to Judge McNally.
Here, Robert Rice.
Robert Rice, I'm here.
You have to start your video, sir.
Sir, I am kind of ignorant to this kind of thing. I've never used it before.
You're gonna start it on the bottom left-hand corner of your screen. Oh, there you go. Your name?
Robert C. Rice.
All right. I'll just make. Did somebody say something? Stop walking around, Mr. Rice. Stay right there, please. I don't know why everybody wants to walk around. Just get a seat.
Sorry, I have a
But
very
we'll make
serious.
sure we have a good connection, okay? Have a seat, please.
I'm trying. If you let me, please let me get to my couch.
Take your time.
Oh. Okay,
He can't pay, so we gotta do 88 days.
I'm here. Are you with me, Your Honor?
Call them up. I wanna
He's
talk.
still in Brownstown.
Yeah, I
You want
want
on Zoom?
to. Yeah, tell him I
I'll
want
leave
to.
this here.
But we're gonna. I got him coming. So just tell them to.
Okay,
Okay.
all right.
All right. I apologize.
I apologize.
You're fine. State your name again.
Robert Currington Rice, Jr.
All right, Ms. Kingsley, tell me what you said again.
Yes, Your Honor. So Mr. Rice is present along with his daughter, Angela Day. Mr. Shearer, the first defendant, is not present. It's my understanding that he currently resides in Maryland. However, Miss Day and Mr. Rice are trying to come up with the funds to pay the past due amount on the loan. It's my understanding that Mr. Shearer essentially abandoned the home and left and said he wasn't going to pay anymore. So they are trying to have Miss Day be able to take over the purchase agreement or apply and be able to purchase the home with my client. And she's already been in communication with my client. So I would just request a 2 or 3 week adjournment so that we can connect all of the parties.
We'll adjourn this to May 19th, right, Jennifer? Or not?
The 20th.
20th?
At what time?
We can do 9:30.
Okay.
So I'm going to adjourn this to May 20th at 9:30. Ms. Day, you can state your name. I know you're not a party here, but I'll let you identify.
My daughter, I left my home of 18 years to come here to be with my stepdad, and he bounced on
Just tell me your name, ma'am.
Angela Day.
All right. I'll make a note that Mr. Shearer didn't appear. It's been going on quite a while.
Yeah, I came home one day, he was gone.
September, this was filed. Why did this take so long? This is May, unless I looked at a calendar.
Your Honor, I believe it was because we had to get an order for a second summons, and then we had to get an order regarding alternate service on both of the defendants, presumably because they no longer reside in the home. So we had to obtain service by certified restricted first class mail and posting to the property.
Okay, so that's fine. I don't need to hear anymore. Ma'am, you don't have really the authority to come in here and speak. I'm just telling you, I was asking you your name for just out of a courtesy, but you really don't have the right to represent your father, stepfather, anybody else. So in the future, while you can log in, and I'll let you do that, you cannot talk on this case, okay? You're not a party. I'm going to adjourn this 2 weeks to May 20th at 9:30. I'm just cautioning everybody, if there's going to be a resolution, you better do it quickly because I'm going to move the case along, okay? It's kind of getting old there. All right. Thank you. Thank you all. We'll see you next week.
Thank you, Your Honor.
I did tell them to call you. I don't know if they had the chance yet. I want a brief on the other one.
Jen sent me an email. I'll get a brief. I'm actually going to be out of the office starting tomorrow, but I'll coordinate with somebody at my office to make sure a brief is filed.
Thank you. Thank you.
Thank you,
All
Judge.
right. Everybody have a good day. LVNV versus Nicole Miller, 2404114. Good luck, Mr. Rice. You're all set, sir.
Thank you, sir. You have a great day.
Two.
Can I get off here now?
Yeah, you're all set.
Thank you.
Where is LVNV?
Your Honor, this Mr. Katz, he's in with one of the other cases for
Okay.
9 o'clock, and the defendant
Discover
didn't appear.
versus Bogner. Discover Bank versus Janet C. Bauher. Baugh.
Looks like Judge Simpson is back. Let's try him again.
That would be great. Thank you, Your Honor. Thank you. Bond will continue with this time. Thank you, Your Honor. Thank you. Court does call the case of the people versus, is it Leorn McEwen?
Morning, Judge.
The prosecutor there, please.
Yes, I'm running on behalf of Leorn McCoon. Ms. Coon, can you please state your full name for the record? Leon McEwen.
All right. You're requesting an adjournment, counsel?
Correct, Your Honor.
No, hearing no objection, May 29, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor. Thank you, Judge.
Thank you, sir. Court does call the case of the people versus Stephane Scott.
And on behalf of the people, Your Honor.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Scott. Can you say your name?
Stephane Scott.
All right.
Your Honor, discovery is complete. We're asking the court to please set this for exam.
People have their witnesses available the 20th.
We'll do our best, Your Honor.
Preliminary examination in person will be set May 20th, 2025, 9 a.m. before Judge. I'm sorry, Barr.
Yeah.
Before Judge Barr. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you.
Court does call the case of the people versus Jason Burkett.
Morning, Your Honor. Christina Costantino appearing on behalf of Jason Burkett. Mr. Burkett, can you state your name for the record?
Jason Matthew Burkett.
Okay.
So just as the date and time set for PCC, at this time, we would be asking for an adjournment of the PCC. There is some additional investigation that I believe needs to be completed.
That objection, 22nd or 29th?
Either one. Either one works, Judge. Whichever the court wishes. Do you have a question?
Of course. 22nd, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Court calls the case of the people versus Tara Sims. Saxon. Is she by Zoom or is she here? Anywhere in the building? Yeah, please. Controlled substance possession.
Apologies, Your Honor. Tina Sachs on behalf of Ms. Sims.
Your name, ma'am?
Tara Sims.
Thank you. All right, what are we doing?
Your Honor, I'm asking for a preliminary examination date, and I believe I
Pardon?
have, I'm asking for a date for preliminary exam, and I believe I have all of discovery.
All right. People have their witnesses available the 20th. Preliminary examination will be set May 20th, 2025, 9 a.m. That is before Judge Moore. Bond will continue.
Thank you, Your Honor.
Judge.
As people are filing in here, a formal good morning to all. Welcome to the Courtroom Files. Happy Tuesday. For the couple of you who I missed, who were in early, who I missed saying good morning to, I was working on Ghosts in the Machine. My chat was not working on this end, but now I have it working, so I can interact with all of you as I should. Cold, rainy, wet day here in Arizona. Yes, Bailey, I agree. It's a good day to sleep, but I didn't. I actually was up at like 3 a.m., so earlier than I wanted to be, but let's get back to Judge.
9 a.m. Bond in this matter will continue.
Thank you. Your staff, stay safe, Your Honor. Always a pleasure.
Thank you. Close it up. Just kidding. Court does call the case of the People versus Jeffrey Stoops.
Ally Zend on behalf of the people, Your Honor.
Edward Drukas on behalf of Jeffrey Stoops in 1422.
Ms. Kate. That'd be anybody from the PD's office.
Sorry, I was trying to see what was going on. Assistant Public Defender, Carrie, really on behalf.
Your name, sir?
My name is Jeffrey Allen Stoops, sir.
Thank you.
Your Honor, in my matter, we're looking to set that for a preliminary examination. I believe Pate was also going to set hers for an exam.
And that's correct.
So the parties, all discovery is complete.
To my knowledge, and speaking with Ms. Pate, I believe it is.
People have their witnesses available on the 20th.
We'll do our best, Your Honor.
Preliminary examination in person will be set May 20th, 2025, 9 a.m. before Judge. Okay, bond will continue.
Thank you, Your Honor.
Thank you, Your
What
Honor.
are you going to do? Just have to fill that out exactly like that.
They could copy the exact same thing.
Hmm?
Copy the exact same thing.
Same thing, right on this one, and then I'll sign off once it's done. Got it? Court does call the case of the People versus Alan Billou.
I think it might be helpful. It's your.
Hello.
Good morning, Your Honor.
B-E-A-L-L, Alan.
Yeah.
A-U-L-I-E-U. Sir, how is your name pronounced?
Baloo?
Baloo.
Yes.
Assistant Public Defender Tanazi Carey, I can rule your honor on behalf of Mr. Baloo. Mr. Baloo, could you state your full name for the record, please?
Alan David Baloo?
Your Honor, we are asking for an adjournment. We have yet to receive discovery in this matter, so we are hoping 2 weeks. Okay.
Probable cause conference will be adjourned May 22nd, 2025, 9 a.m. That is, yes, at 9 a.m. Bond.
Thank you, Judge.
See? Court does call the case of the people versus Shane Stout.
Morning, Your Honor. Edward Lucas on behalf of Shane Stout.
Shane Stout.
Thank you.
Thank you, Your Honor. I'm looking to obtain discovery. I'm asking for an adjournment.
Probable cause conference will be adjourned May 22nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thanks, Your Honor.
Court calls the case people versus Robert Branscombe.
Jacob Kennedy for the people, Your Honor.
Tanazi Carey, I can rule your honor on behalf of Mr. Brent. What is that? Thank you.
I don't think it's going to matter because I don't think he's here.
Yeah, I don't think so, Your Honor. Nope, and unfortunately, Your Honor, Ms. Perroni did send an email and tried to contact our client and with no luck. So we have no explanation for his failure to appear today.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately.
Thank you, Judge.
Just to update all of you on the morning, I've actually got my eyes on 9 different courtrooms at the moment, but everybody is kind of off to a slow start or they've already taken a recess. So the only real action at the moment is here with Judge Simpson. So we'll continue with him and we'll switch where appropriate.
Defendant?
Your name, sir?
Anthony Flanagan.
Thank you.
Your Honor, this matter is before the court today for a competency hearing. When I arrived this morning, I had not received any documentation, but Mr. Ward did provide me with a copy of the most recent report. And I will just say parenthetically, apparently there was another report earlier in this case that I never received. So I'm guessing that's going to the public defender's office, even though I'm counsel of record. But I have reviewed the current report, the one dated April 25, with my client, and we are willing to proceed based upon the findings in that report.
Then the finding in that report upon its review is that the defendant is no longer incompetent, he's competent to stand trial.
I would also stipulate to the court's use of that report, and I have prepared a proposed order which hopefully gets to the court.
Yes, it did. Court, based upon that, will find that the defendant is competent to stand trial, would specifically indicate that at this time the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. All right. So what do you wish?
Mr. Ward and I discussed this. We're asking for a PCC so we can figure out the next step. I know you're setting ones for the 22nd. I was hoping for the 15th, but if the 22nd is the first available.
I mean, I can set it for the 15th.
Yeah, we don't need much time.
Will that work for you?
Yeah, that's
Probable cause conference will be set May 15th, 2025. 9 a.m. Bond continued.
Thank you, Your Honor.
Let's call the case of the people versus Thomas Ellis.
For that, on behalf of Mr. Ellis.
Mr. Ellis, can you unmute and state your name, please?
We can't hear you, Mr. Ellis.
There you go. I'm sorry about that. My name is Thomas Ellis.
Thank you, sir.
Good morning, Your Honor. We are going to be adjourning pending an update on sobriety court referral.
Has the referral already been sent?
Yes, Your Honor.
Probable cause conference then will be adjourned to the 22nd. Should be enough time to get information.
I believe so, Your Honor.
May 22nd, 2025, 9 a.m. bond continues.
Thank you, Your Honor.
Thank you, Mr. Ellis.
Yes, sir.
Court calls case People versus Haley Gregg. So.
Christina Costantino appearing on behalf of Haley Gregg. Ms. Gregg, can you please state your name for the record? Haley Gregg. Judge, today's the date and time set for a PCC. Obviously.
Okay.
I don't know why we always say that.
Yeah, it's okay.
It's
always good to have a reminder.
It's habit. There was an offer that was just recently tendered to us today. I would like an opportunity to discuss that with my client. If the court would consider adjourning the PCC 1 week, I think that would give us ample time. And I know that's a big ask, but she is in custody.
Yep, she is. May 15th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Judge Fleischer has entered the building. Let's say good morning to him.
You have your bond not to drive any vehicle whatsoever for any reason. Do you understand? I don't care what you have to do. I don't care where you have to go. I don't care if there's a burning building and you have to save 50 kids. Do not drive. Do you understand?
Understand.
This is an affidavit that you're going to be signing with me today, promising me that you're not going to drive. Don't do it. I will revoke your bond, put you in jail, and if it warrants it, I can have a contempt hearing. You could be facing an additional 6 months and a $500 fine every time you drive because there's an offense in and of itself. If you want to drive, go get your license, go get insurance in your name, and I will be jumping and doing backflips, taking this restriction off. But if you drive, there will be HE double hockey sticks to pay. Do you understand?
HE double what?
Hockey sticks. Hell to pay. Do you have the ability to hire lawyers, sir? Do you have the ability to hire a lawyer?
Yeah.
Are you sure? Do you want to apply for a court-appointed lawyer? Or do you, you're gonna go hire one?
Yeah.
Okay. If you have any issues, come back and we can talk. I'm happy to give you a court-appointed lawyer if you need one.
Sure.
Okay. I'm gonna have you come up here, Sortis. You're not gonna drive. I'll get you to Victoria Center reset, and then you're out of here.
All right, Judge, next is page 12, Gutierrez.
Adam, you see that's it's an American thing. HE double hockey sticks. Hockey sticks are shaped like L's, so HELL.
This is Edgar Gutierrez Barreto, Judge.
Speaks English?
Yes, he speaks.
Good morning, Mr. Gutierrez. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
It's highlighted for you.
Thank you, Your Honor. On April 28th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a crash and made contact with the defendant and noticed a moderate odor of alcoholic beverage and red, watery eyes. The wheel witness stated that he was inside of his house when he heard a loud bang outside and went out to see a vehicle trying to reverse out of his driveway with the defendant in the driver's seat. The defendant backed into the ditch and the wheel witness told the defendant to stop. The defendant hit the wheel witness's vehicle and a second complaining witness's vehicle. A law enforcement officer arrived and the defendant stated he had been drinking throughout the day. The defendant admitted to hitting both vehicles. A law enforcement officer found an empty beer can on the driver's side floorboard. The defendant was transported to the Joint Processing Center for standard field sobriety tests. A 4 out of 6 was recorded on the HGN, a 4 out of 8 on the walk and turn, and a 4 out of 4 on the one-leg stand. The defendant consented to providing a breath specimen and blew a .094 and a .103.
Okay. Any prior to WIs?
No, Your Honor.
License?
I do not have any data populating for the license field.
He does not have a driver license.
Mr. Gutierrez, number one, I'm going to find there's probable cause to go forward with your case. Number two, you're not allowed to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, I will put you in jail. No more PR bonds. Number three, you'll be signing an affidavit with me today. Everything I said to the other gentleman applies to you. I don't give a rat's behind what your excuse is. You do not drive. This is an affidavit that you're signing with me, promising me you're not going to drive. If you do, I can have a contempt hearing, and every time you drive, it's an offense in and of itself, punishable by an additional 6 months in jail. Do you understand?
Yes, sir.
Nothing in this life can you justify getting into a car and driving. Nothing. I'm going to have you come up here, swear to us that you're not going to drive. After that, I'm going to get you to Victoria. We will have you sign a reset. After that, you'll get with Roxanne for your bond conditions. And after that, you're free to go. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Ernesto. If he tells me he cannot get a hold of you because you're playing games, if you pick up a new case, if you become a danger to my city, I will issue a warrant, put you in jail. No more PR bonds. Do you understand?
I understand, sir.
All right, come on.
Thank you.
Thanks, Mr.
All right, Judge, next is page 16.
Quick educational moment while we wait for the next contestant. It's coming up a lot in the comments on other videos, people asking what a wheel witness is, because that term's getting used a lot all of a sudden lately. Specifically, that is the witness that places the defendant behind the wheel of the automobile, just so everybody is aware of what that is.
Those of you charged with assault, bodily injury, you're facing up to a year in jail and or a $4,000 fine. We're going to do probably that remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Thank you, Your Honor. On March 16th, 2024, Harris County Sheriff's Office was dispatched to 514 Salma Court in Harris County, Texas for an assault call. The complaining witness reported that her ex-boyfriend's new girlfriend, the defendant, assaulted her. The complaining witness got an email from her ex asking her to meet at his workplace in Harris County, Texas. The complaining witness arrived, and as she was getting out of her vehicle, the defendant ran up to her and started grabbing the complaining witness by the hair and punching her, causing her pain. The complaining witness was trying to clarify that her ex contacted her, but the defendant continued to strike the complaining witness and reportedly tried to gouge her eyes out. The complaining witness's ex-boyfriend was a witness and pulled the defendant off of the complaining witness. The defendant was trying to contact more people to show up and also assault the complaining witness.
Any alcohol or anything like that play a factor in it?
Judge, there's no indication of that, and I've spoke to the complaining witness, and it didn't seem so either.
We have a prior assault from 2 years ago, give or take. Any of these same parties alleged in this prior assault?
Different witnesses, judge, and complainants.
Okay, Ms. Mendoza, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of any weapons. You're also not allowed to have contact with the other witness in this case as well. If I find that you do, I will revoke your bond, put you in jail. No more PR bonds for you. I will protect my county at all costs. Do you understand?
Yes, but
This is not a negotiation. I'm ordering you not to have any contact with either of these people. Do you understand?
yes, it's just that he's my husband though, the witness.
How old are you, ma'am?
I'm 25.
You have the ability to hire a lawyer.
No.
I can have you fill out an application. I'll take a look to see whether you're qualifying. I need to know everything about you, ma'am. I need to know how much money you make, how much money you have coming in, money in the bank, cars, stocks, bonds, mutual funds, and then we'll take a look and see whether you qualify. He's going to give you an application. I'm going to have you sign a receipt with Victoria. We'll have you take your seat in the jury box while we get your bond conditions created. Do not leave until you sign our bond conditions. All right, Deputy Miranda will give you the application.
While the defendants are, can I express some of the concerns from the complaining witness?
Okay, hold on, ma'am.
I just want to make the court aware of everything that's going on. Thank you, Judge.
Yes,
So,
of course.
I spoke to her yesterday, and she told me that the defendant's family contacts her regularly, and that the defendant contacted the complaining witness trying to get her to sign an affidavit of non-prosecution. I believe it's the defendant's boyfriend's mother that's been contacting her is one of her concerns. And she states that she's been threatened civil legal action if she doesn't drop this lawsuit. And the defendant's boyfriend's mom, she relayed to me, actually reached back out to her while I was on the phone with her yesterday and was attempting to contact her. And she wanted me to get with her after this court date.
You are not allowed to have any contact, and I don't want to hear that any other parties are trying to make contact with the complaining witness. If I find that they do, it is you that will be in jail at a very high bond. Do you understand? So reach out to the complaining witness, let them know if they hear anything else from any other persons, then we'll bring them back and then we'll take care of it.
Judge, thank you.
Okay. Please, and then if you can file all those conditions.
Yes, Judge.
All right, Judge, next is page 20. Oliver, come on up.
Good morning, Mr. Oliver. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
I apologize, Judge. Could I get the name?
Oliver is the last name.
All right. On April 30th, 2025, a law enforcement officer was dispatched to assist an officer on Barker Cypress Road in Harris County, Texas. Another law enforcement officer stated that he observed a motor vehicle make a U-turn and spin its tires. The law enforcement officer followed the motor vehicle into the roadway and observed the motor vehicle to fail to stop at a designated stopping point at an intersection. The law enforcement officer conducted a traffic stop and observed a strong odor of alcoholic beverage emitting from the defendant's breath and person and red glossy eyes. The other law enforcement officer made contact with the defendant, and the defendant stated he consumed one alcoholic beverage at a hookah lounge called Golden Cadillac. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 5 out of 8 on the walk and turn, a 1 out of 4 on the one-leg stand. The defendant refused to provide a breath specimen. A blood warrant was signed and executed.
Prior DWIs.
No prior DWIs, Judge.
Sure. Can you run a full NCIC, please?
Sorry.
Have you run a full NCIC?
I'll run a fresh one, but from what we have here, I'll run a fresh one right now, Your Honor.
Any like reckless drivings, obstructions of a highway, like a reduction?
It's just
And a license.
No, Your Honor, we have a couple previous charges, but nothing related to that.
Okay. License?
License status. Yes, Your Honor.
Mr. Oliver, I'm going to find that there's probable cause to go forward with the case. I am ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, that includes marijuana, I will revoke your bond, put you in jail, no more PR bonds. Do you understand?
Yes, sir. License is eligible, Your Honor.
Okay, you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name as well. If you do not have car insurance, you are not allowed to drive, and that is a condition as well. You have the ability to hire a lawyer.
Yes.
If we're going to give you time, I will have you go to Victoria, sign a reset. After that, you'll get with Roxanne for your bond conditions. After that, you'll be free to go. Don't pick up any new cases, Mr. Oliver. Don't be a danger to my community. It will not go well for you. Do you understand?
Yes, sir.
Okay, come on.
All right, Judge, next is page 22, Ratcliffe, come on up.
Good morning, Mr. Ratcliffe. Sir, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 28, 2025, a law enforcement officer was dispatched to an assault call in Harris County, Texas. Law enforcement officer made contact with the complaining witness who stated she was assaulted by Jamar, the defendant, and a known Bloods gang member at a local food mart. The complaining witness stated she had a verbal altercation with the defendant, which escalated when the defendant threw a drink bottle inside of the complaining witness's motor vehicle. The complaining witness was seated with the door open and one leg out of her vehicle. The complaining witness stated she was going to call 911 when the defendant closed her car door on this complaining witness's leg, causing pain. The complaining witness then exited the vehicle, and the defendant began to assault her with closed fists. The complaining witness sustained a broken nose and laceration above her eye, requiring 5 stitches. The law enforcement officer made contact with the defendant, identified by his Texas driver's license, and the defendant stated the complaining witness struck him first. The law enforcement officer observed the defendant to have a black eye, and law enforcement officers note that he did not find the defendant credible regarding.
Did you say that he had a black eye?
That's correct, Your Honor.
Okay. Mr. Ratcliffe, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person whatsoever for any reason. Do you understand? So I'm also ordering you as a condition of your bond not to be in possession of weapons as well. If I find that you violate these conditions, if I find that you're a danger to my community, I will put you in jail. No more PR bonds for you, sir. Do you have the ability to hire a lawyer? Yes, sir. Okay, we're going to give you time. I'll have you go to Victoria, sign a reset. After that, I'll have you take a seat in the jury box while we get your bond conditions. Once you sign that, you'll be free to go. Can you file this condition?
Yes, sir.
Bailey says, I'm convinced Ellie joins when you're wearing dark tees. That is actually not true. That is pure coincidence. I don't make my quote-unquote fashion selection until just moments before I go live, and Ellie is usually not in here right away when we go live. She joins a little later, so it's all coincidental.
Yes, Your Honor.
You are Sharika Willis.
Yes, sir.
Ms. Willis, you're charged with theft. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you. And it was Willis, correct?
Yes, sir.
Judge, on August 22nd, 2023, two known employees of a 7-Eleven had stolen $911 worth of lottery tickets from the store. The complainant was stated that at least 9 tickets were missing and that they were worth a total of $911, and that the two defendants could be seen on camera removing the lottery tickets from the glass display and scratching them off without paying for it. The co-defendant and the defendant were engaged in doing this at the same time.
So they're on camera taking it?
Yes, Your Honor.
Taking off?
And scratching the tickets.
Okay. Ms. Willis, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now not to have any contact with any 7-Eleven whatsoever for any reason. If you violate these conditions, you pick up a new case, I will put you in jail. No more PR bonds for you. I'm also ordering you not to have any contact with the co-defendant Walls in this case as well. Ma'am, do you have the ability to hire a lawyer? Okay, I'll have you fill out an application. Deputy Miranda is going to give you one. I'll take a look. I need to know everything about you. Just don't put zeros because I'm not going to believe it. I need to know everything about you. I'll take a look to see whether you qualify. We're going to have bond conditions created for you. Do not leave until you sign them. Okay. Come on.
Are you good?
That's it? Okay. Hi, Marcus. Come on up.
Pushing on Mr. Gonzalez, Diego Gonzalez. He needs more time to pay the DA fee and get the interlock. This is the guy who was just accepted into PTI last week. We were said 1 week so he can get it. He's
274.
I understand. This is the guy who I've approached you numerous times. We're waiting for Ashley Geis to get him into the program. He had the Geico insurance. Geico couldn't get a hold of the CW.
So where is he now? Is he
So-
here?
No, he's not. He's not present because he needs more time.
He has a week. If
Okay.
he doesn't have it in a week,
I'll bring him in.
tell him I'm putting him to trial. By then it's, you're
I-
like 300
I
days.
I understand, Judge, but if you do recall, this is the one that it took forever for Ashley to accept it. It took honestly about a month. So either way, I'll get it done by
A
then.
week to get it, okay?
Okay, thank you, Judge.
We'll wait with you. Have him escort the baby outside, please. So what about the child case? What are we doing with the child case? How many do we have?
We have 2 left.
Okay.
Something about UTI on 1.
What happened with Sexton's case? Did it get accepted?
Yes, Judge, it did. It was accepted.
So the defendant should be here then. What's the last name?
It's Moore. Moore.
Oh, we're gonna hear your honor.
Hey, so you were accepted.
Yeah.
Great.
Sorry, my question. Okay. And bring her, so we just got here.
She here?
Yeah, she's here. Yeah, I just brought her
So
in.
send her now for a TRAS.
Okay.
And then we'll set you off 2 weeks for you to get the contract, get to pay the DA fee and the interlock and stuff.
Okay.
Yeah? Okay. Thanks. Yes, ma'am.
Okay. Oliver?
Good job, Ms. Sexton.
Oliver?
So that's that. Who's the other trial case?
So we had 3 yesterday, 1 got dismissed.
Okay.
PCI.
PCI.
It's in the-
Oh, who's the other one?
The other one is ABO judge. HE.
Do we know the defense's position on your continuing?
I talked to Ms. Victoria this morning. She stated that she got an email.
Ruben gonna be here? Vic? Is Ruben gonna be here?
Judge, I hadn't heard from him specifically.
Can I approach Judge? Are we talking about Mr. Hebert?
Yeah.
I am here on behalf of Ruben Restrepo. He is in trial in Montgomery County.
Is he actually in trial?
And Judge Hudson's office, I believe, sent something over.
Yes, Judge, the coordinator emailed me.
Okay.
That they're in trial?
Yes.
Oh, perfect. Okay, so, well, they have a motion for continuance, so we need to pick a new date.
Okay.
You know what?
I don't know Mr. Restrepo's schedule, but
How long do you think, what's he trying?
it's a DWI. I would imagine that it would be
Misdemeanor or
over.
felony.
Misdemeanors.
So today's Tuesday, why don't we set it for, you think he'll still be in on Thursday?
I would be very surprised, but it's Montgomery County and things are just.
Let's roll it to Thursday so that we can get him here. Hopefully he'll be out by then.
Okay.
Can you just let him know that we rolled it to Thursday? So
Absolutely.
hopefully he can be here and we can try to
Okay.
work out a new date.
Does Mr. Hebert need to be here? He's here today.
No, I guess unless he wants to do something with that.
Okay.
Yes, but other than that, if we're gonna pick a new trial date and they know that that's all they want to do.
Okay, thank you, Judge.
You hear that, Ramona?
Yes, Judge.
Can I give you a cause number?
Yes, Judge.
I'm reading, I need you to do a PC read for me. 256 2060. Last name is Strong.
Law enforcement officers were dispatched to a theft at 5655 East Sam Houston Parkway North to a Walmart. The complaining witness stated that on February 19, 2025, the defendant failed to scan a bag of candy and exited past all points of sale without attempting to pay. This prompted the loss prevention officer to investigate defendant's other transactions. The loss prevention officer observed that the first theft occurred on December 23rd, 2024, and that course of conduct continued up until April 30th, 2025. The total amount for the items taken was $557.67 over the course of this time period.
I'll find PC, and then we have one more. Oh, no, sorry, that's it. That's it.
Thank you.
Judge, you can dismiss the panel.
Yeah.
Well, Bailey, I hope your t-shirt that you're going to wear to your arraignment is at least in the style of Judge West's courtroom standard attire. Speaking of which, the Parade of Orange has started there, so let's say good morning to her.
Try to explain stuff to my client, see if we can get an answer before the next court date, if you would please allow us to do that. Like I said, I know it's an old case, but
And Judge, the offer that I have extended gives the defendant an opportunity to ask for probation due to his age. I'm not in a position to offer that, but so he is aware.
Right.
Mr. West and I have discussed that my offer will not be valid as in the setting. I'm
yes.
ready to move it.
Well, my agreement, I thought it was by the end of the week, but I'll take the next setting too, but I was gonna go by the end of the week. So if we could reset it for.
Because this one has a co-defendant, correct?
Yes,
That's
ma'am. And he was
last week.
Yeah.
So this is going to be the final reset.
That's fine. No, that's
So
perfectly
go meet
fine.
with Mr. St. Clair, go
I
over
know.
everything. Mr. St. Clair, if there's any offer that you want to accept, you need to take that care of that at the next court date. Otherwise, your cases will go on the trial docket and there will be no negotiations after that. Do you understand? Okay, we'll see you at the next court date.
Well, Bailey, you are a channel member. That does not get you any discount on your bond, but it does get you 20% off in the Courtroom Files store. So if you want to rock a sweater or tee from the Courtroom Files store, it certainly can't hurt anything. Just saying.
Good morning.
Good morning. How are you?
I'm good. Let me fill up today.
Are you?
Yesterday was a little bit, Ashley, a little bit of COVID. Today's gonna be.
Everybody's just.
Just take everybody's spots.
I think signing contract sells out. I figured I covered for one.
Good morning. Are you Jetson Bell?
Yes, ma'am.
And Mr. Bell, in cause number 25 DCCR 0108, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon, and that is from January 20th of 2024. Your indictment alleges you were previously convicted of possession of a controlled substance and delivery of a controlled substance, a third degree and a second degree, October 22nd of 2007. And after those were final, you were convicted of unlawful possession of a controlled substance, second degree, February 4th of 2009. And what that means is if you go to trial in that case and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum 25 years in prison up to 99 years or life. Do you understand? And then in clause number 25 DCCR 0109, you're charged with the third degree felony offense of evading arrest or detention with the use of a vehicle. And that's from January 20th of 2024. That indictment alleges those same prior offenses, which again means if you're found guilty and those prior offenses are true, the range of punishment would be that of a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand?
Yes.
And then in cause number 25 DCCR 0110, you're charged with the second degree felony offense of possession of a controlled substance from January 20th of 2024. The indictment here alleges those same prior offenses, again meaning that if you go to trial and you're found guilty, the range of punishment would be a minimum 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
I have here on the computer in each of those cases plea bargain rejections that you've signed with Mr. West that shows that the district attorney's office has offered, if you wanted to enter a plea of guilty, a 25-year term in the institutional division. You have every right to reject that and have your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. You understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your cases set for trial?
Yes, ma'am.
Mr. Nichols, is there any reason in Mr. Smith's file, any notation why this would be,
No, Your Honor, he has the priors that were listed plus a federal prior, which is, I think, still under their supervised release and he's on parole through 2027. I see no reason he would change.
so I want to make sure you understand, Mr. Bell, that after today, I will not accept this plea agreement. Unless there is anything new that comes up, I will not accept a plea agreement less than this. So it's trial, plea open to a jury, plea open to the court, or something different. I want to make sure you know that just getting on the trial docket doesn't mean you're going to get a better deal later. Do you understand?
Yes.
And you want to reject those offers and have all of your cases set for trial. Is that correct?
Yes.
All right, we'll get them set for trial. Mr. West will begin preparation for trial. You can go back with the bailiff.
Adamichi, you might have been on to something. Back when Judge Fleischer was on YouTube, perhaps he should have done channel memberships, and one of the benefits would have been like a bond discount. Can you imagine? I mean, he would have been thrown off the bench if he'd done it for sure, but he would have made a killing. It would have been funny.
Okay, I'll hold it till that's ready. What about Lawrence Glover? I can't, can you come, please?
I'm sorry. I visited him also also yesterday, and he is making a decision. So he's supposed to tell me what he wants to do.
Okay, I'll hold that.
It's gonna be a plea or rejection.
I'll hold it. Thanks. See, Mr. Rojas, you have Chad Smith. I didn't. One's next weekend. It's both. He's on the board of both, I promise. It's, yeah. No, we're all in on all the things. Got to be on the boards and the president of all the things. Good morning. Are you Chad Smith?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
We will, Your Honor.
Mr. Smith, in cause number 24, DCCR 2309, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from September 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, can y'all shut the door, please? Can you, well, I was gonna say, just shut it please. Oh, I'm sorry.
You okay?
Too much going on. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated for 6 years. You would be ordered to pay $1,000 fine and to follow all of the rules and conditions of probation. Is that your understanding? And do you also understand, if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back at a later date for sentencing. Ms. Malfino, what's the state's position with regard to bond based on that plea?
Judge, I'm not necessarily opposed to a bond due to the nature of the underlying offense. Would advise the court that he does have a prior state jail from last 2 years ago for a drug possession case out of Brazoria County. And it also looks like there have been some misdemeanor priors as well, but I defer to whatever you think is appropriate.
Where will you live when you're released, Mr. Smith?
I'm gonna be living with my sister and her husband in Lumberton.
In Lumberton?
Yeah, I've been sober for 1.5 years now. I've been got my CDL, but I have a life waiting for me. I've
Good.
been on the right path. I just needed to take care of this.
Sure. So what I'm going to do, Mr. Smith, is reduce your bond to $1,000. I'm going to make that a personal bond, which means you're just going to be released without having to pay any money.
Okay.
But there's a few things that are very important about that.
Okay.
If you don't show up for court when you're supposed to, then they're going to come after you for the money,
Yeah,
number
of course,
one.
of course.
Also, the first thing you do when you're released today, if it's early enough in the day, is go straight to probation. You're going to get some paperwork today. They'll tell you where to go so they can start that process to do that pre-sentence report.
Okay.
If it's late in the day, go first thing in the morning.
I'm sorry. I didn't interrupt you.
So if you don't do that, then you run the risk of me not accepting the agreement and things could be worse. If you're arrested for anything between now and when we come back for sentencing, also you run the risk of me not accepting the agreement. And did you have a question?
I was just gonna say, that'll all state like which, I'll be in Beaumont for the probation.
Just, if you're living in Lumberton, talk to the, when you're doing that pre-sentence investigation, talk to the probation officer about where you'll be, and they'll start the paperwork to see about courtesy supervision where you are.
So just depending on when they let me go today, whether I go today or in the morning?
Yes, sir.
Okay.
Yep, if it's before 5, then get over there straight today,
All right.
okay? And you're gonna get some paperwork to tell you all that.
Judge, I'll send a dismissal on that misdemeanor so that doesn't hold him up.
Okay, thank you. All right.
Appreciate that.
Yes, sir.
Or sign my name.
Christopher East, Mr. Rojas. How are you today?
Great, how are you?
Good.
Mr. East may want to plead no contest. I told him he'll take those, we'll see if he changes his mind.
Is there any good reason?
No.
Okay. Because on some,
No, Smith does it.
good morning. Are you Christopher East? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. East, in cause number 24, DCCR 1742, you're charged with evading arrest or detention with previous convictions from July 17th of 2024. The indictment alleges you were previously convicted of evading arrest or detention August 21st of 2015. And how do you plead to that charge?
No contest.
Either you did it or you didn't do it. It's guilty or not guilty. Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with? I'm sorry?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Speak up, please. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. East is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with previous conviction, sentence you in accordance with your agreement to a term of 9 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. It looks like the state is going to dismiss cause number 24, CCCR 2313 as part of this agreement as well. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. And George Celestine, Mr. Rojas. The kindest.
Thank you, Attorney Rojas, Esquire.
Good morning, sir. Are you George Celestine Jr.? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Celestine, in cause number 24, DCCR 0746, you're charged with the state jail felony offense of evading arrest or detention with previous conviction, and that's from March 4th of 2024. The indictment alleges you were previously convicted of evading arrest or detention November 28th of 2012 in Hardin County, Texas. And how do you plead to that charge? And is that prior conviction true? Are you entering your plea of guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Celestine's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of evading arrest or detention with that previous conviction. Sentence you in accordance with your agreement to a term of 60 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right? Good luck to you, sir. You can go back with the bailiff.
Let's head west from Judge West to Judge Boyd, who's the best, with purses and flowers where birdies might nest.
Status report consideration for early discharge. Ms. Hernandez has 2 cases. These were sent in and Judge Angelini wanted them to be heard by you, Judge.
Okay.
Here are both reports. She has completed all of the terms of her probation, as far as conditions are concerned. I did speak with the state, and the state is opposed to the early termination for the cases because of the nature of the case, and because I believe Mr. Garahan stated there was the underlying, the actual original plea deal. There were some things in there to where this was the best outcome for it. Ms. Brubaker did prepare to speak with the court today, and she'd like an opportunity to do so.
All right.
I'm sorry, Ms. Hernandez. Keep saying I did it again.
Brubaker brings me up.
That's an MTR.
It's also a movie, but okay.
So I did write something. I just wanted to be prepared.
Sure.
If you don't mind. Your Honor, I want to thank you for the opportunity to speak today. A lot of people told me when I first got on probation that it was set up to make people fail, but I believe that I've proven to this court that they gave me what I needed to be successful. It wasn't just a second chance for me. It was an opportunity to prove that I can turn my life around. My priority has always been to care for my son. One of my most proudest milestones was my son's father and I were able to buy a home at the age of 25. It was important for us to create a stable, secure environment for our son. I now have weekly
Just one moment. Excuse me, could you all whisper? All right, you can continue.
Since getting on probation, I now have weekly appointments with a therapist, and I've been able to create healthy coping skills as I unravel and heal from my childhood traumas. I have 11 months left until I obtain my bachelor's and 3 certifications. I have made the Dean's List twice, and just this week I made the Honor Society. Your Honor,
I love the Honor Society.
I brought it with me.
Okay, I have my Honor Society pen. That's always great.
Your Honor, I want you to know taking a chance on me was not a waste. I recognize how serious my charges were, and I am remorseful for the people that I hurt. I have worked every day since to prove that I am worthy of the opportunity to be on probation. I have learned from my mistakes, and I am fully focused on building stability for my family. I respectfully ask you to take my early termination into consideration. Thank you.
All right. All right. So I see in here that a letter was sent to one of the complainants and it came back. All right. So here's my question. Has she completed everything?
Yes.
And have there been any issues with her on probation?
From my understanding, Judge, there has not been any issues. There was one positive UA back, I believe it was in the December timeframe.
Mhm.
Other than that, all the other UAs have come back negative, and she completed outpatient treatment and everything else. All of her other terms have been completed. She's paid in full.
All right, state,
Yes, sir.
you're opposed?
Yes, Your Honor.
Okay. And it's due to the nature of the offense?
To both offices, two separate offenses of ag assault with a deadly weapon. And so that's one of the main reasons that the state is opposed.
Okay. All right, thank you. Let me just review this for one moment.
I did bring my awards if you do want to see them, just in
Yes,
case.
I do want to see them. And I hope you end up framing them. Of
I
course.
did, so one of them's folded because it was framed, so I'm sorry.
No, no,
It
no.
looks so crazy.
You got to keep it framed.
Yes, I know. I just got my second one last week too. It's a really huge accomplishment for me and my
Oh, this is
family.
awesome.
Thank you. A lot of hard work.
Mhm.
Sacrifices.
Well, congratulations.
Thank you.
Let me see here.
Years late. It's been 6 years since I've been here. Me too.
All right, so. Probation, I'm assuming you all were able to reach out. Oh, okay, to the complainant that I'm reading in here.
Yes, Judge.
All right, so. The complainant doesn't want you off early. And that's something that I do consider, but I also consider. What's the point of keeping somebody on probation if they've successfully completed everything and they've internalized what they've done wrong and they've learned from it? So you had to take anger management. You completed that. What did you learn?
I learned great coping skills, when I feel like I'm getting overstimulated or worked up, or things are not going my way. I learned, healthy habits, how to communicate better, talk myself down, some skills that I've learned instead of just slowing up when things obviously are not gonna go my way,
Mhm.
which I didn't really realize when I was 19 and I was in here. When I was 18, 19 and I was here, I thought everything was supposed to be in my control and how life was supposed to be how I made it. But as I've grown since the 6 years I've been on probation, I realized that things are gonna be what they are and I have to accept those things for what they are. And I have to try to work around those things in healthy ways. And so I've learned, a lot of communication and patience, especially after having my child as well. He'll be 5 in October, so I just have one child, but it's been a lot of ups and downs working on that part, but I feel like I really found healthy ways and a good support system and hopefully you did that as well.
All right. And what did you learn about this specific case and what you did wrong?
My case? Which
Yes.
one?
The case that you're on probation for.
So when I was in here, when I first had the offense, I didn't have any sense of life. I had no direction. When I did what I did, I was thinking in a selfish way. I didn't know because I wasn't living yet. I had no idea what it was to be an adult, what it was to pay bills, what it was to go to school and sacrifice. Sorry. So now that I'm an adult, I realized what I did to stop somebody else from moving in life and putting myself in their shoes. I understand how they feel about being opposed to me as well, because if something altered my life in that way due to the hands of somebody else when I was doing everything in life, I would feel the same way. And so now that I'm an adult and I realize that I'm an adult, that I'm really sorry for what I did. It was a huge mistake and I understand that I altered these people's lives. A choice that I made
Mhm.
that ended up being something that altered their life. And I regret it and I take full responsibility for what I did.
All right, and so if I were not to grant this early termination, what would you do?
Well, if you weren't to grant it, then there's something that you see in me today that it's not ready, and I trust your judgment. If you believe that I'm not ready, then there's something I need to work on to get me to that point. I know that I've been on it 6 years, but if you believe that I'm not ready, then I'm more than willing to do the work to work on what I need to move forward as well.
Okay. All right, and do you think this is a good idea, probation?
Yes, Judge.
All right, so I'm gonna grant your early termination, but it is not going to be granted until the complainant is contacted. And what I'll do is I'll put the date for the granting of it. I will put that on Thursday, the 8th. Would that give you all enough time?
Judge.
All right, so I'll grant it for May 8th. Congratulations.
And if they don't respond, because I think my probation officer was telling me that they had been trying for the last like 6 weeks, is that gonna affect?
Oh,
your
it's May
decision?
8th, but I always make sure in this court, if I grant an early termination, that the complainant is made aware of that, because the last thing I would think you would want to see if you're a complainant, all of a sudden you see someone that you were not expecting to see. So, probation is telling me that a May 8th deadline would give them enough time. So,
Thank
all right,
you.
you're welcome. All right, don't come back unless you're just coming back to say hi.
Okay, thank
All
you.
right.
Thank you, Judge.
Thank you.
I don't need to put that on the docket, do I?
Well, good for her. That's nice to see, and hopefully she's got things turned around. Let's head east to Judge West.
2024, and a motion to revoke that probation filed. Allegations of committing the new offense of public intoxication, testing positive for methamphetamines, testing positive for amphetamines, not adhering to a curfew, being behind in his fees a little bit, and then failing to report for intake in Hardin County. So there was, it looks like, a recommendation of SafeP after a substance abuse assessment was done on April 16th of 2024 that returned to probation May 7th to discuss the recommendation. Denied using drugs, however, allegedly tested positive on that day. And before the matter could be addressed, left the building. Advised his officer that he was going to make arrangements to go to his own detox program in Austin. Probation said, can't pick what you want to do. And so we're here now with the motion to revoke. Mr. Kimler has filed a motion asking that I set a bond. Mr. Wheeler is on a deferred probation, typically entitled to a bond unless there's certain findings. Actually, this is a straight probation. It's a 2/5. Okay, I've received some information that Mr. Kimler sent over. Do you have an
I did see
opportunity
that,
to
Your Honor.
review that? Mr. Kimler, you may proceed. Did you want to call your client?
Well, I think I'll let him decide that, Your Honor. Just in speaking on his behalf, if he wants to address the court, I'll let him do that. But this is a non-violent offense. My first observation, of course, many times when I move before the court, I know that the state argues the safety of the community is paramount in consideration of the bond. I'm not trying to downplay the seriousness of fraudulent use of identifying information offense, but I would just observe to start with that it's not a crime of violence. Mr. Wheeler's struggled on probation. We want to get him back on track, and as part of that, it would be admission to bond where he could report, continue to work, hopefully not have a positive drug screen, so when we come back in front of the court for a disposition of the case, the court's going to revoke him or keep him on probation, they'll be in the best possible position to argue that he should be remaining on probation.
Speak up, please.
So that he would be in the best possible position to ask the court to continue him on probation, if he would have the opportunity to be in bond, show that he can demonstrate compliance.
Okay, Mr. Nichols?
If he's, whatever bond the court deems appropriate is fine by me, Judge. He just needs to monitor, he needs a drug patch, he needs to be reporting. And seems to have a problem doing those things when he was on probation before. I'll note for the court, on a separate probation, he was sent to safety in 2020.
I saw that.
And obviously it has not worked. So I agree, it's not technically a violent offense, but his drug use is concerning, Your Honor.
You want to address the court?
If I may.
Hold on. Raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead.
I have had a history of drug use. When August 4th, my firstborn child was born, and when I heard her cry, I was done. I never touched it again. I put myself in the Franklin house as Land Manor. I went there for 30 days. I'm doing aftercare. CPS was with us. I've done taking 9 drug tests, negative, and a hair follicle. I'm just ready to provide for my family. And that's why I turned myself in, so I can go back and get this out the way and fixed to where I could go to work, because I couldn't get a job because of the warrant. And I'm really excited to be a father. It's really, I'm trying to put this on the right track so I can get moving.
So one of the things I did get one of those letters is from the caseworker that had some positive things to say. So I'll deal with the bond. I'll set one, but what's the plan? I mean, do we not want to go ahead and go through the motion while we're here, and that way we can then set it for, instead of coming back? So will he waive the formal reading of the motion? So we're going to go through this motion, get pleas of true or not true to those allegations, reset it for sentencing, and then we'll talk about the bond and conditions of that in just a minute, okay? So I have in cause number 23, DCCR 1800, motion to revoke your community supervision. Shows that you were placed on probation March 19th of 2024 for fraudulent use or possession of identifying information. That was a 2-year term in the state jail prison that was probated for 5 years. Is that right?
Yes, ma'am.
It alleges you violated your probation. Count 1 alleges that you committed the offense of public intoxication March 26th of 2024. And is that true or not true?
Yes.
Count 2 alleges that you provided a urine sample April 16th of 2024 and May 7th of 2024 that tested positive for methamphetamines. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample April 16th and May 7th that tested positive for amphetamines. Is that true or not true? I'm sorry.
True. Speak up.
Count 4 alleges that you were at a location other than your residence at approximately 11:15 p.m. March 26th of 2024. And is that true or not true?
Yes. True. True.
Count 5 alleges that you are, as of May 7th, 2024, you were $240 behind in your fees. Is that true or not true?
True.
And then count 6 alleges that you failed to report to the Hardin County Probation Department for your intake on April 9th of 2024. And is that true or not true?
It is true. But
True with an explanation.
Yeah, we'll get an explanation later. All right, so did you enter your pleas of true to counts 1 through 6 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I'm not going to do that. I'm going to reset your case for a sentencing hearing and ask the probation department to do an updated report. And so I'll get a little more information about what's going on. Now, with regard to a bond in your case, I'm going to set a bond at $5,000 But you're going to have a condition of that bond if you make it, that you have to wear a drug patch at all times. You've got to have a drug patch put on within 24 hours of your release from custody. If it tests positive, then you're back in jail and all bets are off.
Thank you so much.
If there's more, if you have a drug patch that's not testable, I'm going to assume it's positive. So you need to make sure, wear it properly, do whatever you need to keep it on, and go every 2 weeks like you're supposed to get it tested. I think, I don't know exactly what I'll do. I mean, obviously it sounds like some treatment would be required. Wouldn't hurt to go ahead and get started on some outpatient maybe. But we can wait, or you can go ahead, probation's here, and whatever you think is appropriate at this point while we're waiting on sentencing, give those orders and I'll sign off on them.
Yes, ma'am. I was going to give him a new assessment down to see exactly what it is that he needs to get started.
Perfect. Okay, because it sounds like since the last assessment, there's at least been some treatment, so maybe that'll, recommendation will change. Okay, all right, you can go back with the bailiff.
Yes, sir. All right. I'm going to feel better about keeping on probation to make progress.
Let's head back to Judge Boyd.
All right. Court is calling 2022 CR 9447 State versus Victor Manuel Mendoza. Can I have parties announce?
Galloway for the state.
Sharon Thorne for the defendant.
And are you Mr. Mendoza? For a motion to revoke, please.
Just from a stuttering.
Yes, all right, thank you, got it. Oh, take your time.
Yes, Your Honor. No, yes, Your Honor.
All right. All right, Mr. Mendoza, did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amended Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? These two documents.
Yes.
All right, did you understand them?
Not,
All right, let me ask you this. Do you understand that you're on deferred adjudication for aggravated assault with a deadly weapon?
Yes, sir.
Do you understand that the state has filed a motion to revoke stating that you have violated the conditions of your probation?
Yes, Your Honor.
And do you understand that in these two documents, the first amended motion to enter adjudication of guilt and revoke community supervision and the motion to enter adjudication and revoke community supervision, the state put in these documents the items that they're saying that you didn't complete or how you violated your probation? Did you understand that?
Yes, Your Honor.
Are you the same Victor Manuel Mendoza who was placed on deferred adjudication in cause number, that's the cause number, 2022 CR 9447 for the offense of aggravated assault with a deadly weapon on December 13th, 2022 for a period of 6 years? Is that you?
Yes, Your Honor.
All right, state.
Violation of condition number 1 on or about the 18th day of January 2025 in Bexar County, Texas. The defendant, Victor Manuel Mendoza, committed the offense of criminal trespass in violation of condition number 1.
How do you plead to that? True or not true?
True.
We waive and abandon the remainders.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court is finding violation of condition number 1 true. Is there a proposed agreement?
There is not, Your Honor. State is asking that you revoke and then community supervision and adjudicate him and sentence him to 6 years in prison. The reason that we're asking for this is because this is the third MTR that's come before this court. And he has not used any of the tools that probation has given him to redirect his behavior as played by the new offense that he made.
Okay. And defense, what are you requesting?
Yes, Your Honor. And further, the agreement with the state is that you're going to TIC the 3 new misdemeanors.
Yeah.
Okay. There are 3 new misdemeanors, Your Honor. My client does have an explanation for these 3 misdemeanors, but he is pleading true. And as you can see, he has a severe stuttering situation, but he wants to explain, like one of the offenses was a failed ID. And I believe the officer really couldn't understand him when the officer said he wouldn't give his name, but
Okay.
my client would like to explain his situation, but he is accepting responsibility. So would you like to tell the court about your father, grandfather, and that you need to be home with your mom?
John message. My step my stepdad was in another hospital. Yeah. My stepdad was in another hospital my stepdad was in another hospital. I had lost track. I was taking care of my mom and my stepfather just passed away and my stepfather had just passed away just about 2 months ago.
Victor, can you tell the court,
Well, if he's going to give testimony, I'll have him raise his right hand. Or do you want to proffer what he's going to say?
can I proffer what he's going to say?
Yes.
He recently lost his stepfather. His mother requires his help. He does have a severe stuttering disability. He believes that the failed ID was a miscommunication with the officer because the officer didn't think that he was answering his question. And you could see, Your Honor, he has a very difficult time communicating. He had a criminal trespass that's also that he's accepting responsibility for, but he said that that was also a misunderstanding with I guess the store owner. It was a Dollar Tree. As you can see, Your Honor, my client does have a severe stuttering and communication issues. He does understand that this is his 3rd MTR. He does understand that he is going to be looking at revocation. He is simply asking the court to show mercy on him as far as a sentence. I know the state is asking for 6. We are asking for less. And he does have some credit, Your Honor, and I've been checking with probation and with your clerk as to his credit. He has 403 days, and he also did ISF twice, so that's another 183 days. So he should have 586 days total. We are asking this court to show some mercy on him and to sentence him less than the 6 years, giving him all full credit that he has earned.
All right. And state, what cases are you taking in consideration?
That would be 2025 CC 001646 criminal trespass. 2025 CC 005683 evading arrest. And then the 2025 CC 005637 bill tied to it.
All right. So this is what the court understands. The failure to identify. Maybe there were some communication issues, but the evading arrest, there's no communication issues with that. For example, you're able to understand what I'm saying. So the evading arrest has nothing to do with verbal communication. The criminal trespass really has nothing to do with verbal communication, because when the people at the Dollar Tree tell you to leave and give you a warning not to come back, then you're not to come back. And if you come on their property, then it's a criminal trespass. This is the third time you've been before me. And your attorney has told me that you had some issues going on with your family. I always tell people, all you have to do is let your probation officer know. And if you feel as though they're not responding, you can come back to the court. And I know I would have told you that because this is your third motion to revoke. There's only so much work that I can do to try to help people. And if you don't want the help and you're not going to do right, there's nothing I can do. The court is finding violation of condition number 1 true. The court is going to find you guilty. The court is going to revoke. There's an affirmative finding of deadly weapon. Was there any restitution probation that was ordered? All right. I'm going to give you credit for any time served. I'll give you credit for successful completion of ISF. Taking consideration 2025 CC 001646, 2025 CC 005683, 2025 CC 005678, and I'm sentencing you to 6 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? It's this document that tells you whether or not you have a right to appeal. Did you review it with your attorney? And states you may be excused. All right. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Good luck to you, sir.
Thank you.
You're welcome. Yes.
Let's try to head back to Judge Fleischer. Looks like he might actually have some things to do now. He'd been just kind of staring at his computer for about the last 20 minutes.
Mr. Patrick, you're charged with burglary of a motor vehicle. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge.
Oh, I have to give you a cause number. There's a warrant because he missed court. 255-9022.
23? Is it?
No, it's 255-9022.
Yes, sir. 22, sir. Judge, on April 7, 2025 in Harris County, Texas, officers were dispatched to a burglary of a motor vehicle call. The defendants were located and matched the description the complaining witness gave to the officers. The complaining witness stated defendants entered the vehicle and tried to steal it by breaking the ignition cover. The complaining witness stated her neighbor was leaving for work and it scared the defendants off. The defendants left a screwdriver in the motor vehicle. The complaining witness stated the ring camera caught the incident. The co-defendant was found to have 2 key fobs on his person, and both key fobs belonged to other individuals. The screwdriver and gloves were found in the defendant's backpack, and a ski mask was found on the co-defendant's person. The defendant provided false information, and the defendant was eventually identified by mobile AFIS.
There's so many holes in this thing. I mean, how do we know it was him? Was he in the car? Where did they catch him? Did they go running after him? I mean,
Judge, if I can just.
it's a complete disjointed. Submitting now.
Judge, the law enforcement officers were dispatched and were given a description of 2 individuals by the complaining witness who had it on a ring camera of the individuals breaking into a vehicle. And
Do they see him? Does the report say that they saw Mr. Patrick?
just a description given, Judge. And then the law enforcement officers on dispatch located the 2 defendants nearby.
Does it say that there, or are you assuming?
Sue and Burley, they advised the last direction of travel being east of the residence and northbound intersection of Maryland. After a brief search, both defendants were obtained on foot, matching the description provided by one complaining witness. The complainant advised that they made entry into her vehicle. and it advised they attempted to steal the vehicle by breaking the ignition cover. The Due to a manufacturing flaw, upon exposing the ignition, the vehicle can be started without the ignition key. The complainant advised her neighbor directly across was leaving for work, and both defendants began to leave on foot when they heard noise. And then they found a screwdriver was found on the vehicle floorboard. The complainant advised that her doorbell camera captured the incident and provided a positive description of both suspects, both being males wearing dark hoodie sweaters, black pants, both slender in build and being tall, and the one being tall and one being short. After a pat-down search of the defendant, defendant 2 was found to have 2 key fobs stuck into his pants, and one fob belonged to a Dodge that was connected from another burglary of a motor vehicle. That was not charged maybe here, Judge.
Is Mr. Patrick defendant 1 or defendant 2?
He's defendant 1, Judge.
He doesn't have the key fob. It's the other gentleman.
That's correct, Judge.
He's the one that has the stuff in the backpack.
Just want to verify that, Judge. That's correct.
Patrick, I'm going to find that there's probable cause to go forward with your case. You live in Houston, dude. You don't live in another state. People like their guns and they like their cars. And when you mess with the wrong person, they're going to shoot your ass dead in a heartbeat to keep what's theirs. How many countless stories do you hear of someone running away from one of these types of situations? They get shot in the back. It's only a matter of time. Was this in the middle of the night?
It was early in the morning, Judge, around 6 a.m.
Patrick, I'm going to find that there's probable cause to go forward with the case. I am now going to put a whole host of conditions to make sure that you do not fall through the system or the cracks, because we don't need another statistic or we don't need another person dead. Do you understand me? The first is that you are not to hang around with the co-defendant in this case. You are not to use alcohol, illegal drugs, and I'm going to send you for a test right now because I want to know what, if anything, is in your system, and you're to come right back. Do you understand? If you fail the test, if you fail to come back, it's not going to go well for you. I'm now also going to put a monitor on your ankle so I know where you are at all times. One false move, you will stay with me. I need your help, Mom. I can't do this alone. You and me together, we can make this thing work. Tell me about it. What does he do? Is he in school now?
Well, yes, I'm in school, so he did go to school. But
Okay. Wonderful.
he did have sign up for a job, so he was looking for a job, so he do have a job.
Well, what I was going to do is I was going to order him and only give him time so he can go to school, and then he goes back home. And then he stays at home, doesn't go anywhere else. I don't want him out in the middle of the night. You're not to be in possession of any weapons as well. If I find that you have any weapons, if I find that you pick up a new case, it's not going to go well for you. I will protect my city at all costs. I don't care what you are, how old you are, anything. Do you understand? We will work with you to make sure that everything works together. I'm going to pay for everything so you won't have to pay for anything. I'm going to give you a lawyer today. So we just need to know what schedule. Do you work?
I work Wednesday through Saturday.
And then you're out.
Then I'm off.
I mean, you're out like out working. My only fear is that when the cat's away, the mice will play. So that's why while you're at work, he stays at home. I'm going to test you like crazy to make sure that you're not using anything. Do you understand? You must stay in school full time. The GPS monitor will tell me where you are at all times. And if you leave school, try to skip class, I'm gonna skip your bond. Do you understand? Okay. Shoot.
So, just a couple of years on, so him that, you don't have to come to me right now, because we're not going to work for him. So, yeah, I wish to,
Okay, so let me get your lawyer. We got to figure out a schedule because I don't want him out just hanging around and doing whatever. If he gets a job, then we can work with a schedule. But other than that, I probably just got to stay at home. You know, I don't want him out just just screwing around because, you know. Okay, we'll work together. You must listen to mom. If mom tells me that you start acting like a knucklehead, you will stay with me and you will earn your degree with me behind bars. Do you understand? If she tells you to jump, you ask how high. Do you understand, Mr. Patrick? Okay. All right, mom. Please, and just hang tight and then we'll hook you up. That way. Hi, Emma.
Good morning, Judge.
Are we gonna need a translator on your guy?
You will.
Okay, Vic, we need a translator.
Okay.
I'll send it out to you.
Thanks. Anna,
Good morning, John.
hi.
I've got two to talk about this morning. The first one is Kennedy. Kennedy,
Kennedy.
she's on bond.
Okay,
This case has gotten older. We were waiting for the packet from the lab. We still don't have it, but the state has made us a PTI offer.
okay.
And so if I, okay,
And if you're gonna accept the offer, let's get it done and what
oh, she's accepting the offer. So I just need some time for her to finish the class.
do you have to do?
It's just a drug and alcohol, awareness class. Okay, perfect.
She doesn't have it done, she gotta be here.
Perfect.
What else?
The next one is Quinn.
When?
Yes.
Okay,
This one, we've submitted a mitigation packet. The state has made us a new offer. It's still a deferred. But my client, if he could get just a little bit of time to talk about it with his mom, because while he is,
happy with it or are you unhappy with it?
the deferred offer.
And
I mean,
does he have any priors?
No prior, Judge.
it's,
184, I guess we'll give you a week as well.
okay,
Let us know what you want to do.
okay, okay. Thank you. Maybe excuse.
All right, let's head back to Judge West.
And Ms. Randall, in cause number 25 DCCR 0246, you're charged with the state jail felony offense of theft of property with previous convictions. That's from November 21st of 2024. Your indictment alleges you were previously convicted of theft April 4th of 1984, April 11th of 1985, April 10th of 1989, November 12th of 1991, October 10th of 1994, May 6th of 1999, April 17th of 2008, August 24th of 2015, April 29th of 2016, November 28th of 2016, and then February 11th of 2019. And what that means is that
There's
Judge, you
also
allowed us a little bit of time last week. when we had
Yes.
This issue, I feel like just to be on the safe side, we have marked third degree. I've gone through the priors. There's a lot of underlying misdemeanor priors that some of them to be plucked in.
So, Ms. Randall, what that means, as you heard, is at least for you would be facing punishment of a third-degree felony if you go to trial and you're found guilty, which is between 2 years and a 10-year punishment, with the possibility of it being a second-degree felony, and that would be between 2 years and up to 20 years. Do you understand? And then in cause number 25 DCCR 0247, you're also charged with theft of property with previous convictions. That's from November 16th of 2024. Same prior offenses are alleged in that indictment. Same thing with regard to punishment. Do you understand? And then in each of those cases, I have here on the computer plea bargain rejections that you've signed with Mr. Parker that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty for 4-year terms in the institutional division of the Texas Department of Corrections. I want to make sure you understand what your possible consequences are and what your options are, and do you understand all of that? And do you want to reject those offers and have your cases set for trial? And Ms. Malfino, is there any reason to believe that these offers would change?
No.
I want to make sure you understand, Ms. Randall, that after today, I will not accept these plea agreements. Once your case goes on the trial docket, it's going to be tried in front of a jury, or it would be a plea to something other than this, but not less. Do you understand? Okay, and I will get your case set on the trial docket. Mr. Parker has been appointed to represent you at this point. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you? Mr. Parker, you're released. Ms. Randall, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. Okay?
Judge, just, if I may, for the record, in addition to providing notice of whatever enhancements I can, I would also, most likely file a motion staffing sentences.
So I want to make sure you also understand, because these offense dates were different dates, that if you're found guilty in each of these cases, the state can request that any punishment you receive, I run consecutively, which means stacked on top of each other. I'm not telling you I'll do that, but that could be something that could happen in your cases. Do you understand? And do you still want to move forward with trial in both cases? All right, we'll get it set. You can go back with the bailiff.
All right, let's keep hopping around Texas and we'll go back to Judge Boyd.
Of 10 years.
Mhm.
Judge Angelini, sua sponte, ordered a PSI with a setting of 2 June.
So
for
you're
the
asking
PSI.
that you're waiving the PSI?
I would certainly like to waive the PSI, and also, Your Honor, Judge Angelini took Mr. Murphy into custody because he was an hour late the day prior to the
So
plea.
now we know it should be on time, right?
Yes, ma'am.
All right. And see, people always come to me, they would say, oh, Judge, it's just 9 a.m. Then when another judge fills in for me and it's 9 a.m. and you're late, instead of getting a lecture, you get custody. I don't know. Should I start doing that, Attorney Featherston?
Judge, for the right individual, it may be a proper way to get their attention.
Okay. And you're saying that's not right for your client?
Well, I'm saying that his attention has been gained and that he is respectfully requesting that the court lift his custody.
Right. You know what I always tell people when they're late for appointments, and this is how I was raised. If you're late for an appointment and there's no emergency, like I'm not on the side of the road, I had an accident, or I'm in the hospital, what you're telling that person is, I have something that's more important than this appointment I have with you. That's basically what you're telling the person. This whole thing, I'm showing up fashionably late. No, that's you saying, I have something more important than to be where I'm supposed to be. So make sure you're always on time. All right. All right, the court is calling 2025 CR 005188W State versus Dustin Murphy. Can I have parties announced for the record?
Andrew Harris, with the state.
Robert Featherston representing Mr. Murphy.
And my understanding off the record, I was informed that you all had completed all of the plea paperwork. The client had entered his plea. And what was your plea?
Guilty.
All right. According to the plea, the state is recommending deferred adjudication. They're asking that you defer.
At this moment,
Well, no, I mean, you haven't been working for 2 years. In that 2 years where you were unemployed, how were you supporting yourself?
I was living at home with my mother.
I don't understand why mothers allow this. So was your mom working?
Yes,
So how would you spend your day?
trying to find a job.
Through what hours?
In the day hours.
Do you have any children?
I have one.
How old?
1 month.
And where is the 1 month old?
She's in Fort Worth.
With her mother?
Yes.
All right. So what drugs have you used in the past?
Methamphetamine.
Anything else? Have you ever been to prison before? Have you ever been to jail before, other than this time? For what? Oh, and I'm sorry, state, you may be excused.
Graffiti, marijuana.
How far did you go in school?
All the way to high school.
Did you graduate?
Yes,
And what are you planning on doing with the rest of your life?
being a father,
And how are you going to accomplish that?
by getting a job and take care of my daughter.
All right, what's your dream job?
Dream job.
Mhm.
Anything that can get my daughter to where she needs to be.
Okay. All right, this is what the court is going to do. Do you want to speak to the length of deferred, the length? The state is asking for 10 years.
Judge, we agreed to a 10-year deferred. I had discussed with Mr. Murphy that there is an early termination provision within the statute and discussed with him in detail what he needed to do in order to become eligible for early termination.
All right, 10 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs. In custody, I'm going to want a referral to felony drug court. Your attorney will explain to you what felony drug court is. You need to be honest with them because I think you do have a major drug problem, as evidenced by the fact that you're here, as evidenced by the fact that in the past you've had meth, as evidenced by the fact that you've been unemployed for 2 years. You understand? So you need to be honest with them and do your best to get in that program if you truly want to be a better person for your child. You understand?
Yes, ma'am.
So that will be in custody. And if he's not accepted, TAP evaluation in custody, proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. 200 hours of community service restitution. I'm going to order parenting classes. Once he completes the parenting classes, community service hours will be deemed satisfied. Field visits 1 time per month until further notice. There's going to be 120 sober meetings in 120 days. Take in consideration 2025 PF 04413, 2025 PF 05766, 2023 CR 8453. And this is to run concurrent with 2025 PF 04414. And just one moment. There's to be no contact with Robert William Shivers, SHIVERS, and no contact with Robert Jeffrey Gornato, GORNTO. And what's your mom's name?
Diane Murphy.
And you're not allowed to reside with Diane Murphy. Probation, is there anything else?
No, Robert, last name again.
GORNTO. And there's to be no unsupervised contact with minors. And CPS compliance if applicable. I don't know if CPS is involved or not, but if they are, he needs to follow their rules.
All right, Your
Probation, is there anything else he needs? Is there anything else you need from the court to be successful on this probation?
Your Honor, may I ask you to reconsider a few items?
Sure.
If he's not allowed to live with his mother temporarily, he's going to be homeless. As he doesn't have any income, doesn't have any financial wherewithal to rent an apartment at this point. Would the court consider giving him a move-out date of 1, 2, or 3 months to give him time to get on his feet and obtain an apartment with some income that's coming in. Otherwise, it's really setting him up to fail on the 120-day, day for day, and the other conditions that the court would like him to be able to accomplish. Additionally, Judge, we were here with Judge Angelini. The TAP evaluation couldn't be done before the 2nd of June because the lady that was doing the TAP evaluation also was doing the PSI evaluations. And that was the earliest she
Well,
had
I
on
will
her
tell you,
calendar.
if he is honest with felony drug court is going to accept him. And if they accept him, he's not going to need to be there for the TAP evaluation.
Okay, thank you, Your Honor.
All right, so, Ms. Abrams, I'll allow him to reside with his mother, but after, June 27th, he's no longer allowed to reside there. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right, we can go off the record. Let me just explain to you why I'm not allowing you to live with your mother after that date. Because you're an adult male, you need to support yourself. And sometimes mothers, it's a mother's love, and it's very hard for moms to do the tough love thing and give you deadlines. So I've just given you a deadline.
Yes, ma'am.
And
Thank
whether
you.
you have employment or not, you're gonna have to figure it out.
Yeah, thank you.
All right. In this court, communication is key if you want to be successful on probation. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can always come to court.
Yes, ma'am. Thank
All
you.
right, good luck to you.
Thank you, Your Honor.
Thank you. You're welcome. And Ms. Abrams, make sure the felony drug court evaluation is in custody.
All right, let's go back to Judge West.
We would be waiving, in order, he's habitual 2599. In order to get to the 10 years, I think we need to waive.
I said just proceed on count one.
Does that get us? Yeah.
It gets us 10.
Yes, we would waive or abandon our both punishment paragraphs.
Okay, thank you. All right, Mr. Glover, in cause number 25 DCCR 0287, the state is elected to proceed on count one only. It alleges you committed the third-degree felony offense of assault on a public servant from January 28th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Smith?
I did, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No, Your Honor.
It's admitted. Is there any evidence that Mr. Glover is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a public servant, sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. This will run concurrently with any other time that you're serving on a parole revocation as well. I am handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Smith. Good luck to you, sir. You can go back with the bailiff. And then, Mr. Smith, you have Calvin Randall.
Yes, Your Honor.
Does he have somewhere to be? I can't wait to let everybody else. I'm taking care of the ones that have been here for a minute.
What's going on, Bruce?
Hey, Lou, there you go.
Doing well.
Good morning, sir. You're Calvin Lee Randall. And Mr. Randall, in cause number 24 DCCR 1278, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from May 17th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And then in cause number 24 DCCR 1529, you're charged with the second-degree felony offense of unlawfully carrying a weapon on alcohol premises from May 17th of 2024. If you're found guilty in that case, the range of punishment would also be between 2 years and up to 20 years in prison. Do you understand? And then in cause number 24, DCCR 1530, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from May 17th of 2024. In that case, what that means is if you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? And then finally, in cause number 21, okay, so we've got an MTRP.
Yes, sir.
Okay, and that one, you're on probation for aggravated assault causing serious bodily injury. Based on the nature of that underlying offense, Mr. Nichols, what's the state's position with going ahead and setting the, I'd rather go forward on the motion, honestly, maybe?
I'm looking at Mr. Smith's offers in the case, and that all seems to line up. I don't see why we wouldn't, Your Honor.
Set it for, obviously it would take some time. We could set aside half a day and go forward on the motion. It's just as serious as the others, so just as soon get that taken care of. And then if we still need trials at that point, we can get the rest set for trial. So let's do this. I'd like to go through that motion. Hold on a second. On those other three cases, before we move to that motion, I do want to go through real quick. I've got plea bargain rejections that you've signed with Mr. Smith that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty. Looks like to 16-year term in the second degree felony offenses, and where am I? 16. Were they all, the evading arrest or detention was it, is it?
It should be a third, Your Honor.
Y'all wrote 16 on it also, but obviously that's not. So what's the offer with regard to that one?
I would imagine if you pled to the others, that would be dismissed, Your Honor.
So it looks like the offer would be to dismiss the evading arrest or detention with the use of a vehicle for pleas on the aggravated assault with a deadly weapon and the unlawful carrying, those second degrees, for 16-year terms in those cases. Do you understand? And do you want to reject those offers and have your cases set for trial? All right. So then let's go through. Give me a sec, I'm trying to get it.
Do you want my copy or?
No, I need to, I just had to save it the right way here. Best you can, raise your right hand for me. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can put your hand down. Well, that's an administrative hearing. Why is this coming up? I'd saved the wrong thing. First amended motion. Well, it was saved. The first amended motion was, here it is. Hold on. I don't know why. Sorry. Here we go. In cause number 21-36882, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation August 30th of 2021 for the offense of aggravated assault, family violence, and that was a 10-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department February 21st, May 25th, June 13th, October 12th, and November 5th of 2023. And is that true or not true?
Not true.
So you reported on those dates?
I had,
I mean, and hold on. Well, Mr. Smith, I want to make sure if some of them are true, I mean, if he wants to plead not true to everything, that's fine, but
Well, I was just thinking, Judge, for purposes of this morning, this plead not true.
no, for purpose, he's under oath, if it's true or it's not true. So if you reported, fine. If you didn't report, fine. We're going to get explanations later.
okay.
So if what I'm reading out to you is not true, obviously the new offenses we're going to have a hearing on. But these administrative violations, if you didn't report, you didn't report. If you did, you did. All right? So on those dates, is it true or not true that you failed to report?
True.
Okay. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 alleges that you provided a urine sample on July 3rd of 2023 that tested positive for tetrahydrocannabinol and methamphetamines. And is that true or not true? Count 4 alleges that you failed to provide verification of performing the community service. Is that true or not true? Count 5 alleges that you failed to provide verification of entering and successfully completing the BIP or an anger management program. Is that true or not true? I'm sorry?
True.
Count 6 alleges that you're behind in your court-assessed fees as of December 5th of 2023 in the amount of $3,192. And is that true or not true? Count 7 alleges that you committed the new offense of aggravated assault with a deadly weapon May 17th of 2024. And is that true or not true?
Not true.
Count 8 alleges that you committed the new offense of unlawful carrying a weapon on alcohol premises May 17th of 2024. And is that true or not true?
Not true.
Count 9 alleges that you committed the offense of evading arrest or detention with the use of a vehicle May 17th of 2024. And is that true or not true?
Not true.
All right, so I'm going to, did you enter your pleas of true to counts 1 through 6 freely and voluntarily? The counts that you pled true to, 1 through 6, did you do that freely and voluntarily? And because those are actually true. All right, then I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. I'm not doing that today. I'm going to reset the case for a hearing so that the state can, those are all from the same date.
Yes, Your Honor.
Correct.
I should be able to prove them up.
And so we will set this on a date when we're not in trial so that we have a few hours for that. And then we'll see where we get after that and get the other cases set for trial if we need to. All right? You can go back with the bailiff. And I do want an updated report, please. We need to get your fingerprint, please. Okay.
Let's play Texas ping pong one last time for the day, and we'll go back to Judge Boyd.
You can ask the deputy to have them move your client down. Court is calling 2024 CR 011-276, State versus Froilan Guzman Velasquez. Can I have parties announced?
Megan Galloway for the state.
Rafael Leal for Mr. Guzman Velasquez.
And are you Mr. Guzman Velasquez?
Sí. Yes.
All right, we have an interpreter here. If you could raise your right hand for me. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do.
Thank you. Defense, do you speak Spanish?
Yes, Your Honor.
And do you speak it fluently?
Better than anyone.
All right, I'll be the judge of that.
All right. May I speak in Spanish to you?
Sure, it's gonna make it difficult for the interpreter, but of course. Were you able to explain all of this, all of the documents that are in English to your client in Spanish?
Yes, Your Honor.
Mr. Velasquez, all of the documents that I'm going to be reviewing with you are in English. Were those documents explained to you in Spanish?
Yes.
Counsel, have you received all discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Velasquez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor. The state moves to waive and abandon count one and proceed on count two. Regarding count two, we move to proceed on the lesser included offense of kidnapping. And we are proceeding on the repeater enhancement. However, I do have a motion to amend the enhancement allegation. The date of the conviction is listed as the 21st day, and it should be the 25th day after the judgment.
All right, any objection to the waivers?
No objection.
Any objection to proceeding on the lesser included offense?
No objection.
Any objection to the changing of the date on the repeat offender enhancement allegation?
No, Your Honor.
And Mr. Velasquez, do you understand that in the repeat offender enhancement allegation, the state is changing the date from January 21st, 2021 to January 25th, 2021?
Yes.
Do you have any objections to that change being made today?
I'm sorry, I did not understand.
Do you have any objection to those changes being made today?
No. No.
Do you have any objection to proceeding today?
No. No.
Did you review the admonishments with your attorney? Did you understand it and cite it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included of kidnapping with an enhancement? If the state is able to prove up that enhancement, your range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Do you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, I do.
Mr. Velasquez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, did you retain an immigration attorney for your client, or did you have an immigration attorney speak to him?
Yes, Your Honor.
All right. Mr. Velasquez, have you had a chance to speak with an immigration attorney?
Yes.
Do you understand by entering this plea, you will be deported and not allowed re-entry into the United States?
Yes.
Do you understand that you will be denied naturalization?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count 2, the lesser included offense of kidnapping. You agree that you've been convicted of 1 or more felonies for purposes of enhancement. Punishment is to be assessed at 15 years in the prison. There's a $2,000 fine. There are no applications. The state will take in consideration 2022 CR 10958B. Did you understand that to be the plea?
Yes.
Defense is at the plea.
Yes, Your Honor.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense of kidnapping, how do you plead? Guilty, not guilty, or no contest?
No contest.
To the enhancement paragraph, how do you plead? True or not true?
What part, I'm sorry?
The enhancement paragraph that states that you've been previously convicted of a felony. How do you plead? True or not true?
True.
State any evidence.
State offer, state one in attachment.
No objection, Your Honor.
All right, state two may be excused. Did you review the document entitled Wavering Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we have had extensive negotiations with the state. I believe my client understands and is willing to take responsibility and wants to proceed and close the case, and so he can be on his way and proceed with his life. That's all I have.
All right, this court will do. Court will sentence you to 15 years in the prison, give you credit for any time served. There's a $2,000 fine, time and money to run concurrent. Take in consideration 2022 CR 10958B. There's to be no contact with Rafael Vela Padilla, no re-entry into the United States, and restitution, if any, to Rafael Vela Padilla. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. You need to internalize what you did. You're here, you're not a citizen, and then you're bleeding and taking from other people who are not citizens. That's not a good thing. You understand? You cannot build your happiness off someone else's misery. And while you're in prison, you need to think about what you did wrong to be in the situation that you're in, and you need to correct it. Because I don't think that you would want any of your children, if they were trying to come here, I don't think you would want them to be treated the way you treated this person. Do you understand?
Yes.
Good luck to you.
Thank you.
You're welcome.
Thank you.
Do you need me to sign?
Okie dokie. Before we call it a day, Bailey, you were asking about the stats that I shared a while back on probation, and I couldn't find that sheet anymore. I don't think I saved it, but I reran the statistics from the Bureau of Justice Statistics while we were watching that last interaction there, and here's how it all breaks down. The national average for successful completion of probation is about 65%. As of 2021, 2.9 million American adults were on probation, which is a crazy amount to me. Top 3 failure reasons are technical violations, new offenses, or simply absconding. If you are on probation for less than 1 year, your success rate is 70%. If you're on for 1 to 3 years, it's 60 to 65%. If you're on for over 3 years, it's under 50% success. So the longer, to answer your specific question there, the longer the probation seems to go on, the less likely you are to succeed. I always kind of bristle when she does like these 10-year deferreds and stuff like that. I just, realistically, that's a long time for somebody to not step on a landmine, especially in the United States where, you know, our code books are this thick and the pages are, they're that Bible paper, you know, that real thin stuff. It's just a crazy amount of laws. We have too many laws. Crazy amount. Anyways, I've also broken it down by offense type. For completion rate, if you're on a drug-related offense, the average is 60 to 70% of successful completion. Property crimes, it drops to about 60% successful completion. Violent crimes, down to 55% success rate. DUI actually is the highest at about 75% success rate. By age, if you're under 25, you've got a 50-50 shot at completing successfully. 25 to 34, it goes up to 60%. 35 to 49, 65%. And if you're over 50, 70+% completion success rate. So no surprise there. The older you are, the more likely you are to succeed. Ethnicity seems to play a role as well. If you are white, about 67% chance at success. If you are black, about 57% success. And if you are Hispanic, about 62%. Again, this is from the Bureau of Justice Statistics. This is not stuff that I made up or anything like that. It's just stuff I was able to pull off the government website. So there you go. All right, we're going to go ahead and leave it there for today. I hope you all enjoyed yourselves today. Do me a favor, if you would. If I've earned it today, please smash the like button on the way out. If you're not a subscriber to the channel, please consider doing so. If you go to the pinned comment in the chat, you'll find 2 links. One is to sign up for our newsletter, which we're going to start running here towards about another week or two. that doesn't cost you a dime. Please do sign up for that. I'd appreciate it. If you think I've earned it and would like to become a channel member, that's $2.99 a month. That money goes straight back into the channel. And oh, by the way, a special thank you to Brent, MD, and Patty, all three of who became channel members within the last day. So I appreciate you guys for that. And yeah, please do. Also, if you'd be so kind, I'm really trying to grow this show, which is why we're also streaming on X and Rumble, trying to get to more places, because this is my favoriteest thing to do. The best way that you can help us grow is to share this show with your friends. So if you have social media and you would be so kind, please do share on your social media about this show. Share a link, get people involved, and that's the easiest way for things to grow. Or just go knock on your neighbor Bob's door and say, "Hey, Bob, tune into this channel." Anyways, we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. I look forward to seeing you all again. In the meantime, have yourselves a great Tuesday. Take care, and God bless.